This is the third session on copyright reform in Nigeria, Uganda, South Africa, and Kenya. And I'm Dr. Melissa Omino. I'll be your chair for this session. We have the immense pleasure of having Professor Caroline Ncube here to give us an introduction for this session. And Prof. Caroline Ncube is the research chair in intellectual property at the University of Cape Town. Not only is she a research chair, she has dealt with intellectual property policy on a regional level, including the African Union, several regional economic communities, and several intellectual property offices in different countries.
Thank you, Melissa. Good afternoon, everyone. What my task is to take stock before we start this really interesting session. So what I think we've done is throw down a lot of challenges on the table. And we want to hear from government representatives how they think they can meet those challenges, having taken on board what practitioners said in the morning, what some academics and civil society said just before lunch, to see what they think the way forward would be. And so in taking stock, then, I thought I wanted to make these 5 points. And the first of these 5 points is that context is critical, right? We are zoning in on the continent. We're talking about Africa, and we're talking specifically about what the issues, the priorities, and what the opportunities are for us on the continent as we chart our way forward. And looking forward, of course, to try and come up with a balanced copyright system for the continent that meets our priorities and that sets out a future that benefits the citizens of the continent, right? So this is the big aim. How do we go about that? What are the 5 critical things that we need to think about? So the first thing that I think we need to remember is that context is critical. We are focusing on this continent, but Africa exists within the globe. And to a certain extent, we are stretched, right? So there are a multiplicity of fora at which copyright reform is taking place, right? So we know it's taking place in a number of African countries. We will focus on several in this panel: South Africa, Kenya, Uganda. We'll talk about those, but we also know that internationally, a lot is going on. So the first point I want to make is context is critical. There are many sites where reform is being pursued. There are many sites where negotiations are taking place. What are these sites? As we take stock, we know internationally one of the key ones would be WIPO, the World Intellectual Property Organization. We know that there are other international sites where we talk about copyright and where what we say there matters. So we could talk about UNESCO, we could talk about the WTO. So there are a number of sites internationally where a lot is being said about copyright, and we need to keep our finger on those pulses, so to speak. Then when we come onto our own continent, we know that we would be looking at a multiplicity of places. We would look perhaps at the continental level. We know that the African Union is doing certain things. We know primarily at the level or at the side of the African Continental Free Trade Area, we have the agreement. We know that we have an IP protocol, and a lot is happening at that level. That's continental wide. We can say regionally. We know that also sub-regionally, there's a lot going on. We've got the regional economic communities that have some mandate that has to do with intellectual property. For example, we know that the Southern African Development Community SADC adopted IP guidelines in 2018. We know that we have 2 regional intellectual property organizations, ARIPO and OWAPI, and then we know that we have the national level. So a multiplicity of levels, a multiplicity of sites where all of these things are going on, and our government officials are hard-pressed. They are pulled every which way. They have to manage all of these different fora and see what's going on there. So we have all of these sites, and at all of these sites, we have many, many issues being debated at those sites. And what's really great about these 4 days that were together, split between the 2 sites, Johannesburg and Cape Town, we're talking about these issues. So I won't talk about the issues. Safe to say there are so many issues as we've been speaking about. So many sites, many issues. What issues then does this raise for us? So I'm down to point number 3 now. It raises for us resources and alignment. And when I say us, I'm speaking really broadly. All stakeholders. It would be for us as academia, it would be us as the creatives, it would be us as the government officials, it would be us as policymakers, and us as legislators. So all of us have to navigate how we deal with our resources and alignment across these different angles. So what kind of resources am I talking about? I'm talking about resources of humans, resources of expertise, resources, even financial resources, because if a state has got to send representatives to all of these multiple fora so that it's represented, that's money, that's expertise, that's sometimes even travel, right? So there is some resource lag that's required and investment. There also then has to be alignment. If you've got a state speaking at all of these different sites, dealing with all of these different issues, you do need to have alignment. And often we speak about this gap between the capitals and Geneva. If you pay close attention, you sometimes find that what one state is saying in its capital here on the motherland sometimes tends to be different to what its representatives may be saying in Geneva or in Washington or in Accra or somewhere else. So we do need alignment between what a state is saying at the different sites and on the different issues. And so for me, this is why a panel like this is really important, really critical, because it brings representatives of different African states. It's just a moment in time, it's just an hour, one afternoon, but at least it gets us together so that we can have an opportunity to raise the challenges, the priorities, the opportunities, and indeed the challenges that we face. And this is a way of opening up dialogue so that we can hopefully align our resources and also align, in fact, what the positions are that we're taking on these very many different issues. And this then leads me to the last 2 points, which would be agency competence, competition, or cooperation, and then moving together towards a common African position. So because there are so many sites of reform agenda setting, reform agenda negotiation, and whatever you want to call it, there does tend to be, in a sense, some kind of tension between the different agencies. You start to wonder who has the mandate to deal with this, who is the one who should be the sole custodian of debate or pursuance of this issue. And when that tension is not maturely resolved or discussed or put clearly on the table, what that might unfortunately lead to might be some competition, which is, I think, completely unfortunate, and we shouldn't have that. Once we start to have competition between the different agencies, that only stretches the resources that we have and then leads to misalignment. And so I'm hoping that between the government agencies, the government representatives that we have here online in person, that we can perhaps start to speak about how to get away from the agency competition and move towards cooperation. And the thing that should bring us towards cooperation is because we're all moving towards a common African position, right? We all have this vision for an Africa that has an intellectual property that serves its people, that is balanced, that serves the public interest. And so if we're starting from that perspective, I think we can gradually move away from competition towards cooperation. Thank you.
Thank you so much, Prof. So we are now trying to keep up with Prof. I want us to get straight into the government officials who are here. We have government officials from East, West, and Southern Africa. And I'm going to ask that we start with Gladys Isaac-Ojo. I hope I got that right.
It's all right.
Okay, I'm going to ask her to start off. And before she starts off, I need to properly introduce her. 1 second. Gladys Isaac-Ojo is the Assistant Director, Legal Department, Nigeria Copyright Commission, the NCC. And she's going to give us some details about the copyright reform that has been happening in Nigeria. And after Gladys, just so that I can prepare her, we're going to have Sharon Chahale-Wata from Kenya, who will also be giving us the Kenyan perspective as the Deputy Executive Director in charge of training and research at the Kenya Copyright Board. But to start us off, over to you, Gladys.
Thank you very much, Melissa. I have been introduced, so there's no need for the introduction anymore. Once again, my name is Gladys, in case you didn't hear her say it. Assistant Director of Nigerian Copyright Commission. So I don't want to bore us with where we are coming from. Before we got to this point where we are in Nigeria, before we now finally got the new Copyright Act, which was passed into law in 2022, we of course are coming from somewhere. The first legal framework for Nigeria was a copyright framework, was introduced in 1911. That was the English copyright law. We moved from there, from 1911, we moved to the 1970 Act, which was the first attempt at codifying copyright law in Nigeria. After 1970, we moved to the 1988. There was a 1988 amendment. Because of lapses that we had in the 1970 on, we moved over to the 1988 on, which was, regarded as most forwarding, because it made provisions for a broader array of copyright works and protection. That's 1988 on, and it also created what is known as a Copyright Council, but with administrative functions only. From 1988, we had an amendment in 1992. Designating copyright officers, all employers of Nigerian Copyright Commission, designating them as copyright inspectors with the power to prosecute, to enforce, to arrest, and to investigate all copyright offenses. After 1992, we had one in 1999 with a further amendment, and at that point, it became codified in the laws of the Federation of Nigeria. Then after the 1990s, 92, we had another one in 97. I don't know if I've said that already. Then between 1997 and 2012, nothing happened again. So the present reform that we have it as it is now started in 2012 by the Nigerian Copyright Commission. The reason for the reform was that at that time we now had the existing law then did not have taken into account the new and emerging challenges of the digital space. And again, the Nigerian creative industry was also expounding and begin to enjoy international recognition and acceptability. And again, copyright infringement was on the rise because the penal sections or provisions were not stringent. So these were some of the reasons why we had to start this reform in order to be able to align with international best practices. So in 2012, it was formally launched with a roadmap towards to guide the commission or the nation how the reform would go. First of all, an expert working group was constituted from the commission and outside the commission to develop a roadmap, with which the reform, will be guided. After that, there was the technical unit that was also constituted to come up with the first draft. After we did the first draft, it was sent to the just before then. After the first draft, it was published for stakeholders to make their comments and inputs as regards the draft. Then after the back and forth, the first draft was sent to the Honorable Attorney General of the Federation. The Nigerian Copyright Commission is an agency under the Ministry of Justice, and the person in charge is known as the Honorable Attorney General of the Federation and Minister of Justice. So the first draft was sent to him. After he had looked at it, it was sent back. After the back and forth, the final draft was sent to the Federal Executive Council for vetting, which was later sent back to the ministry. Then finally, sometime in 2018, it was sent to the National Assembly. So at that time, at about the same time, a private member bill was sponsored from the private civil society. At the same time, the government went to the National Assembly, and then a public hearing was held after that, comprising of government officials as well as members of the civil society and with relevant stakeholders in attendance. At some time in 2021, the upper chamber of the National Assembly assented to the bill, then and passed into the law. It went to the lower chamber. They also gave their assent. Then it was now sent to the president for his assent. And the new copyright law was passed into law in 2023, but named the Copyright Act of 2022. So I have done a bit of the history. So the highlights in the new Copyright Act include, first of all, like I said, before the reform started, the internet age had come into play. We had so many infringements going on in the internet space. So we have several provisions. We have provisions on copyright infringement on the online space. Well, let me start with the policy objectives of the copyright reform. If you look at the Copyright Act in Section 1, it's clearly stated there. The first objective was to strengthen the copyright regime in Nigeria to enhance competitiveness of the creative industry globally, in line with the digital and knowledge-based economy, and also to facilitate Nigeria's compliance with obligations arising from international copyright treaties, to provide adequate protection for the right of authors while balancing it with the public access to creative works for a balanced economy, and to also strengthen the capacity and the enforcement powers of the NCC. This is the policy objectives behind the copyright reform. Then I have talked about provisions and major highlights of the new Copyright Act. I will start with the 1 minute. Okay, yeah, sorry. Sorry, definitions of copyright now the definition of copyright is now equally applicable to the digital space. Copyright inspectors are renamed copyright officers, are renamed copyright inspectors. Provision of enforcement of copyright in the digital space. We have special exceptions for the blind and the visually impaired, and increased penal sanctions. Now, but in this case, we do not have the upper case. We only have the the lower limit. You know, in the provisions, you will see if you commit this offense, your punishment is at least 1 million naira. The judges are allowed to, give an upper limit depending on the severity of the offense. We also have an expanded meaning of fair dealing with a detailed means of determining what amounts to fair dealing. Provision of offense of aiding and abetting. We didn't have that in the old law. Then there is a provision on copyright licensing with a novel one which has to do with copyright licensing for public interest. I know that a lot of us are very interested in this because that's the reason we are here. Public interest, copyright and public interest. We have a provision in the Copyright Act that allows a user to approach the Nigerian Copyright Commission for a special license to use a work in line with public interest or in favor of public interest. But the thing is, at the moment, we have not activated this section because regulations that will help to activate this section are still in place. Yes, they're yet to be activated. But one thing I want us to know or take away from here is that it is an exception. It's not a rule. And it is intended to serve public interest. It is not intended to serve any individual person or any individual business. It is for purposes of serving public interest. And the rights that will be given under that section will be limited to the exact public interest for which it is sought and for a limited amount of time. And also, whatever decision is given in that regard by the Nigerian Copyright Commission is subject to judicial review. Thank you very much.
Thank you. I couldn't stop you earlier because you were saying something very important about that particular exception. So we're moving from Nigeria, which has a special exception for licensing for public interest. And now we're looking at Kenya to see what are the reforms that have happened there. And to guide us through that is the very able Sharon Chahale-Wata, who is the Deputy Executive Director, Training and Research, Kenya Copyright Board. I'm doing that so that you don't have to introduce yourself.
Thank you. In Kenya, our law has undergone several amendments in the recent past, yeah? Just to pick a few, 2019, we underwent some amendments. Mostly the difference was introducing comprehensive provisions around CMOs, because that was such a big issue for us. And then domesticating the Marrakesh Treaty after we had ratified it. Then 2020 came another amendment, which basically made provisions for ISPs, the liability for ISPs, and introduced what we call a takedown notice, so that whenever your work is being infringed upon online, then you can issue a takedown notice and the ISP is obligated to pull it down, yeah? Then in 2022, we had another amendment, and you can note the spacing between the years, yeah? In 2022, we had another amendment, and basically this one was entrenching registration in the law. Initially, registration of copyright was kind of implied, because the law was saying that we need to keep a database, but this time we were actually spelling it out within the law. That is in 2022. And then now we have Copyright Amendment Bill of 2025 that seeks to overhaul the whole act. There is a lot of things that we are introducing, including even changing the name of the Copyright Office. We are now called Kenya Copyright Board. We want to call it Kenya Copyright Authority and expand the mandate. We are also trying to expand the mandate of the Copyright Tribunal because it has been very narrow. And so one of the things we want to do is have the Copyright Tribunal deal with a lot more issues than what they currently have. Currently, they have only 2 mandates jurisdiction. They can deal with copyright registration. When we refuse to register, you can go to them. And then they also deal with CMOs. When we refuse to license a CMO, that's it. And that's it. And we do licensing once a year. So you can imagine how bored and idle they are, yeah? So we're trying to give them a little more expansion so that they could also listen to infringement kind of matters and more of that. Of course, with the lawmaking process, I'm sure it's almost same everywhere where the bill can originate from. The executive, individual members of the House. But there's also one thing I found very interesting, that a member of the public may petition Parliament through Article 119 of our Constitution. So we, as members of the public, can petition Parliament when they want to do a bill or an amendment like that, yeah? In regards to exceptions and limitations, we have always had exceptions and limitations in all those laws I've talked about. I mean, the same act, but the different amendments. We always had something on the exceptions and limitations, especially for research. But now in the current proposed bill for 2025, we have expanded that a lot. We have expanded a little on the issue of fair dealing to include research, which wasn't there before. Research and private study for non-commercial purposes, we have introduced that. Also, copies for text and data analysis for non-commercial purposes is an exception we have introduced. We are seeking to introduce, let me say that, in the 2025 bill. Then lending of copies, libraries and archives, also we have introduced that. We have expanded that a bit. Yeah, but we have had challenges in terms of these many amendments, yeah? As I said earlier, there are different ways in which the amendments could be introduced in Parliament. And one of the times we found that the amendment was being pushed by a member of Parliament because of political reasons. And in the process, some group had gone to her to say, delete these ISP provisions, which we introduced in 2019, and this was 2020. So she also was proposing to delete a section with no explanation, no reason at all, yeah? So that is one of the challenges we have had. You have political interests when you're trying to do these amendments. Kenya Copyright Board itself, we have moved ministries many times. For a long time, we were domiciled under what she was calling the equivalent of Nigeria, the Ministry of Justice. For us, it's the Attorney General's office. So we were domiciled there for a long time. And then we moved, some regime moved us to the ICT ministry. And then we moved to sports, youth affairs, and the arts. And currently, we're now in the gender, culture, the arts, and heritage. That movement hampers whatever you're pushing, yeah? Because then you have to push through your ministry and whatever else. So that's a big, big challenge for us. There's also there has been talk of merging the IP offices in Kenya. Right now, the copyright office is on its own. We have the industrial property office. And then we have an organization called the Anti-Counterfeit Authority. So the proposal is to merge the 3 offices. The proposal has been there since 2013, but now the president recently in a cabinet meeting pronounced himself on it. So you can imagine. Initially, when we did a bill, an IP bill, to try and amalgamate these offices, we had proposed that you have a bill creating the IP office and say it is going to administer the Copyright Act, trademark, and whatever. But what they tried to do was to merge all these acts into one act, which was very chaotic, yeah? So we hope that this merger is going to be smooth, but these are some of the challenges that have been hampering us in terms of, working on the law and the different things that you need to do. And of course, just the issue of public participation on the bills that we put out. Whenever you put out public participation, you may even find, for example, IFLA will give you comments, but you will not get comments from librarians in Kenya. So people are not participating as much, and so they that also has been an issue. And of course, the low level of awareness when it comes to matters copyright and all that, yeah.
Thank you so much for that, Sharon. I was keenly observing if you are going to mention the President's Cabinet Notice, and you have, so I have nothing to say. I'll wait for the Q&A. I'd like now to invite Agaba Gilbert, who is the Director of Intellectual Property at the Registration Services Bureau in Uganda, to give us the rundown of copyright reforms in Uganda. And Agaba, you have 6.5 minutes.
Thank you. Good afternoon, ladies and gentlemen. Good afternoon.
Good afternoon.
Yes. Thank you. First, I would like to thank Recreate and PIJIP for bringing us here and giving us this platform to learn from each other. I'm honored, of course, to sit at the same platform with Professor Ncube here. The other people you read in books, and so when you're sitting with them, you feel you have arrived in life. From the IP office in Uganda, it's called Uganda Registration Services Bureau, and we are responsible for administration of intellectual property, all types of intellectual property, except plant variety protection, which lies elsewhere. And I was interested to find that most of the issues that are being reformed are almost the same. So when Professor was talking about alignment, I felt all the issues we are looking at are virtually the same. It seems we are in the same season, and we really need to see how we can leverage on what we've learned from each other to be better. So we have a Copyright Enabling Rights Act. It's from 2006, and that law was driven mainly by our membership to the WTO, where we're required, of course, to update our intellectual property laws. But good work was done on it, and it's a really good law, except that users, and particularly the authors, found it rather impracticable for reasons that I'll get in maybe a little bit later. So this law was proposed in 2018 to amend it, primarily to bring it in line with the new digital economy that had wreaked havoc on the industry. As in all countries, most of our creators were used to analog things which were working for them because the analog system allowed them to control distribution. But then when the internet came, plus computers, this model got lost. Everything was destroyed. Those who owned the work could not control how this work could be distributed, and therefore it was not possible for them to control how they will be rewarded when they put their work out onto the market. So to address this gap, we started interventions to see how we can bring our law up to date. One, by domesticating certain treaties, starting, of course, starting with Marrakesh, where the blind society in Uganda was very proactive. I noticed that the same in South Africa is obtaining, so they really know how to coordinate. They are very pushing, and we started with domesticating that treaty, the Marrakesh VIP Treaty, and later in 2022, we domesticated the Beijing Treaty, the Berne Convention, the WIPO Copyright Treaty, and WIPO Phonograms and Performances Treaty all at the same time. Then we had elections, and one of the opposition members was a musician. Most of you may have heard of him. It's called Bobby Wine. And then creativity and, of course, IP became a center of attention for government. How do we ensure these people stay in the industry and don't find us here. So government said that we need to rush through this process and update the law. And we did, I think from our perspective in Uganda, one of the largest consultations on the law ever on record. We went throughout the whole country taking opinions from virtually all types of authors, users, and everyone in between on what this copyright law should cover. So the issues that we are dealing with, of course, was to domesticate the ratified treaties, adapt our law to the new technological environment, issues of ISPs and so forth, wanted to see how to provide for them, then deal with new distribution models. Many musicians were complaining about something called ringback tones. I don't know whether you have them here, complaining that they were making 2% from the money that telecom companies were making, and they were up in arms. And actually, that was their only issue. When we talked about amendment, plus, of course, the private copy levy, which some of you may have in your national laws. And finally, we need also to strengthen supervision and operations of collective management organizations. So we did a bill. We submitted it to Cabinet. They passed it in a record time, like I said, due to the obvious political connotations. And it's going to actually be published when I go back home. The issues maybe which we've noticed from the reform and which will necessitate us again go through this process maybe in a couple of years is most of the authors or owners of works really mentally they have not come from the analog world into the digital world. They still, as one man has said, want to make music or film great again. But we cannot go back to that time. And it's very hard for most of them to come to this era. They need to know that things have really changed. The business models have changed and these kinds of things. That was one of the first challenges. The second is that the issues that they are very much interested in are really issues of bread and butter now, but maybe the foresight is still somewhere off. And as such, we are dealing with issues that will be overtaken by events even by the time the law is, the bill is passed into law. So something like call ringback tones, I believe the proposals are not sustainable. But that one I'm telling you here, don't tell those musicians. Yes. And
you have 30 seconds.
Okay. And maybe the other challenges, the CMOs themselves, they are run by members and they do not want to change how we are supervising them. They want to maintain as it was. So the law, we are waiting when it goes to Parliament to see what will happen, because then politics will mix and then we don't know what will come out at the end. So if we have another chance to come and explain about the reforms, don't be surprised when I tell you totally different things than what we are talking about today. Thank you.
Thank you so much. Next, we are going to have Vivian Katujuongwa, I hope I've said that properly, the former CEO at the Business and IP Authority in Namibia, who will be rounding off the discussion from the different governments in the region.
Thank you for the opportunity to be able to at least share with you. I come from Namibia. Many don't know where it is. It's bordering South Africa north. So I think I'm the one who came here fastest, 1 hour, 45 minutes. So in terms of Namibia, our history is very, it's linked to the South African legal system. So prior to independence, which was in 1991, we were governed under the South African laws. So the 1978 Copyright and Neighboring Rights Act, I think it's probably still the same that we have at home, because post-independence, we then had it to be the 1994 Act. And there have not been major amendments except for the creation of the Business and Intellectual Property Authority, which is now similar to CIPC, where we are responsible for both business registration and intellectual property, which includes copyright. But prior to that, copyright was then under our Ministry of Information and Technology. So when BIPA was established, then it moved to BIPA now to be the authority responsible for that. So what we then did is, in terms of, having this law that is a 1994 law, and there are many issues that have been mentioned by the previous speakers that have not been attended to, like bringing the law in compliance with the agreements that we've now signed as an independent country like Marrakesh and so on. So it's an opportunity for us now to update the law. But we also, for example, have national development plans that run for a certain period where we have to bring out those objectives and so on. So what we did, I think it was around 2019 when the minister then gave us approval to proceed with the amendments to the law. And so we started with the layman's bill. We got a lot of assistance, for example, from WIPO and other universities and so on, where we had resources that assisted us with really laying out that initial draft. So the rationale, as I said, to really make the amendments was, for example, alignment with international and national obligations. It was also to look at the new developments like the impact of technology and so on, and how we can address it or give effect to that, and also the rights of our creators and the performers and so on, which the old law did not address, and also to give significant attention to the culture, folklore-related issues. So we saw there are various gaps that we identified when we went through this process. So it's one of the key issues is that when you look at copyright, there's also the issue of money, and money going to the actual performers and the authors and so on. So we looked at the issue of introducing the copyright levies, also to provide for the resale rights to the artists themselves, and then to look at the issue of enforcement, because there was no enforcement mechanism where you have infringements and so on. And then, of course, the treaties that are indicated. So where we are today is that if you look at the new law, what it proposes, it covers areas like the enforcement, the artist resale rights, the reproduction by libraries, archives, education institutions and museums, the exceptions for those living with, perpetual impairments, and then protection of expression of folklore, technological protection measures, rights management information, voluntary registration of rights and organizations. There's an objective to create a copyright and related rights fund. Then the levies that I spoke about, and the management and overseeing the governance of the CMOs by the authority. And then there are also issues that pertain to orphan works. So where we are, so we had a good start with this whole process. We also had the opportunity to go to Parliament and try to educate the parliamentarians on the whole issues of copyright, so that when the bill goes to them, they at least appreciate what the issues are that they have to focus on. Now, what came in is that we had elections last year, so we're going to have a new parliament. So we then said, look, we need to hold back a bit because we have to now retrain. So after March, there has to come an opportunity where at least the new parliamentarian and the National Assembly get an opportunity to be introduced to the subject matter, because it really facilitates the whole discussion. I think for us, the shortcoming, or maybe, is that our civil society, for me, it's not as active and as vibrant as what you have here. So sometimes you feel that there are laws that go through, but the discussions are not as rich as they should be. Or the people who would be most affected by it might not even be aware or appreciate what is happening. And I think that is an area that one has to really work on, so that you also have good literature on the issue when if there are issues that come to court and so on. The other issue is this morning we were talking about how do you protect your rights and so on. And the only forum that is available are the courts. And courts are expensive. As we all know, it takes a long time for cases to be there, and copyright is not a priority area in many jurisdictions. So what happened last year, for example, at BIPA is we established a mediation center. So the staff members were trained to facilitate mediation. So if you have, for example, right holders who have issues, at least you try for them to come together and see if they can amicably resolve the issue instead of getting into the court system. So it's a way. Then, of course, we have the voluntary licensing also that we facilitate. And it's really for them to have that evidence base to say, this is my copyright, and then the ability to amend as well. So from my side, I hope that come the new government after the 21st of March, that at least it would be one of the priority bills that can at least be taken forward then. Thank you.
Thank you so much, Vivian. You are perfectly on time. So in Vivian's intervention, she made mention to civil society and how she would like it to be more vibrant in Namibia. And that really is a wonderful segue into the next part of this session, which is the discussion from civil society. And I would like to ask Selaus Ogbonaya from African Knowledge Initiative, Wikimedia Nigeria, to have an intervention, and you have 5 minutes only, and I'm strict with time.
Okay, thank you very much. So when it comes to the issue of copyright reform in Nigeria, we have a base problem, which is the fact that for the kind of governance structure we run, you cannot say what would happen 8 to 10 years from now, with or without personal analysis of what's on ground. Now, the government has so far made a giant, step in the right direction with amazing provisions in this new act. I mean, our section 20, subsection 1E, now makes a very interesting provision for the freedom of panorama they yanked off. And now not just the public, perhaps artistic work, sculptures and all, are being recognized by what looks like a freedom of panorama, but also audio visuals are now recognized, which is great. However, when it comes to the time we live in, and of course how big Nigeria is, I actually would have hoped for a better approach in consultation in terms of getting feedback and all. We have a joke in Nigeria: no matter how inaccessible your word or your community is, a ballot box would always find their way to you. But when it comes to issues like this, it's about, let's discuss with these guys in silos. Let's discuss with maybe this group in silos. So with that, we could be in this, discussion for the next 10 years. And I'm not saying this to be a pessimist, because what we don't have the luxury of is a coalition like this in Nigeria. Nigeria is a very big country. And every day, a star is born in Nigeria. Creatives are coming up every day. In fact, I can tell you that up to 30% of them are high school students. In trying to consult, get feedbacks, they may have at some point become passionate about singing, about rapping, or whatever. But they may not have had the opportunity to contribute to the suggestions, to the conversations. And then someone like Rema, who is very big, started when he was like 16, 17. And then he went from secondary school to signing a multi-million-dollar contract that he knew almost zilch about copyright. Yes, he could get the services of a lawyer to interpret things to him, But I feel that, in our approach, especially in Nigeria, we should stop making it, I wouldn't say an adult conversation, but, reserved for professionals, for specialists, for lawyers, etc. Why? Because despite the fact that this reform conversation had started in 2012, some people would jumpstart their careers and find themselves in these, environments where these copyrights are actually enforced without having a full understanding of what it entails. Another gray area that the Nigerian copyright reform has left to, I would say, the Nigerian judiciary, in whom we don't have so much trust as a people, is for AI-generated content. In fact, what it takes to do a rap album now in Nigeria could cost between $10,000 to $20,000. But if you were to give me $250 as an indie, what they call independent artist, I can make you an AI album that sounds dope. If you want R. Kelly singing on the tracks, you have R. Kelly. If you want Alicia Keys there, she's there. In fact, I could squeeze so much of the AI juice to create a fictitious AI musician for myself. You may want to think, oh, it would lack soul and whatnot. We've actually done this. There is a friend of mine who works with Chocolate City, one of the biggest labels in Africa, Eclipse Nkasi. There's an album on Spotify and YouTube Music called Echoes. Look for it. What did he do? Went to SoundRaw, got an AI to generate an instrumental, maybe in like 4 different concepts, R&B, Afrobeat, which is our thing, hip-hop, trap, and whatnot. Went to ChatGPT, gave ChatGPT an instruction and prompt, and ChatGPT came up with lyrics for each of those tracks. Then he went to 11 Labs, which is a text-to-speech AI. You guys should check it out. It's dope. And it came about these synthesized voices. Great. It could give you pitch bends, anyhow you want, ad-libs, falsettos, vibrato. You have everything an average, Tyler could give you on the track. And now the Nigerian new Copyright Act has left this open, saying that for an actor, for an artist to actually get remunerated by a work generated by AI, they need to have put in some effort. How do you quantify some effort? Does it have a period of time? Because AKA is late, one of the greatest rappers from South Africa. I could want him on a track, but I can't reach the guy. And I use an AI, to adapt his voice on a track. It would have been nice if he could earn something that is stipulated by the law. He has family left behind who need to be catered to. So in engaging younger people, we could have had the possibility to say, oh, this is cool, this is not cool, because if it's done to me, I would have loved to earn some royalties. It doesn't have to be much, it doesn't have to be 50%, it could be 10, it could be 30. So kudos to the Nigerian government for coming thus far. I was shocked that, before Muhammad Buhari left, he was able to sign this in March 17th, 2023. However, like she rightly said, there are regulations. Yes, out of the goodness of their hearts, the Copyright Commission had actually chosen to veto over some, circumstances. For fees, by the way.
That should be your last point?
Yes.
Yes.
For fees that up to this point, we don't know what it will cost. I can remind you once again that minimum wage in Nigeria is around $50 to $65 per month. So who are paying these fees? What are they earning monthly to be able to pay these fees? I think I will just leave us to wonder. Thank you.
Thank you so much, Salwas. Yeah, there are so many questions I have, and I only let you talk because you started talking about AI and AKA. So now I'm going to ask Sandra Acheng, who is the Executive Director of WUGNET, which is the Women of Uganda Network, to give us her perspective as part of the CSOs about copyright reform in Uganda.
Thank you. I was keenly listening to my brother Gilbert speak, and he was able to really give a good overview of what is happening in Uganda in regards to the Copyright and Neighboring Act and also the current bill. And also just letting you know that I wear many hats, and today I will speak majorly about the Wikimedia and just thanking them, because I think when I joined the Wikimedia ecosystem is when I started learning about copyright and how it's important. Because Gilbert, you will agree with me that Uganda is a country that still needs a lot of awareness in regards to copyright and how important it is, and the valuation in regards to that. And I will go straight to us being able to have one of the countries with the best policies regarding the copyright, but also there's a big challenge, as we've all heard, with the implementation of laws generally, but also the user involvement in the development of policies that is really important, especially with the civil society, and also most importantly with communities of Wikimedia that are across the world. That would be very important. What does copyright really even mean, and what does intellectual property really mean? I think I will want to highlight issues around the piracy that is very common in Uganda. If you walk to any movie library, you will see movies of, I think, different people around the continent and translated into other languages in Uganda. Then you wonder, do these people know, do they have the copyright to reproduce these movies? But also looking at the aspect of content monetization and also the AI-generated content that Ceslaus also talked about. And one incident that I saw on Twitter was a prominent journalist that moved from Uganda and is now based in the US. She was one of the very critical government official, very critical journalist that was very a critic of the government. So then they used our image and it was uploaded on ChatGPT or wherever AI platform it was, and then they whoever did that bleached her and then made her look really light. And there are people who are really trolling her on Twitter and other platforms, and they're trying to say how she has moved now to the US and now she's looking in another way. So how that would affect a person who is, first of all, a journalist and also who is a woman, because I'm a woman rights activist, but also generally as anyone would be a victim to such kind of aspect. So there's a lot of enforcement of the copyright law, which is very weak, and piracy remains a very important and rampant issue, especially in the context of Uganda, with a lot of copyright laws that is around illegal downloads, unauthorized reproduction, and content theft that needs to really be worked on. And I think also the aspect of the limited fair compensation of creatives that has been mentioned, especially by many people. I don't want to go into that. And also Gilbert talked about the coloring back tone that also generate very significant revenue, but I think artists still really only receive a small friction due to the unregulated revenue sharing model. And again, the low awareness and education that is really important. And that's where I will go straight to what we are trying to do as the Wikimedia Community User Group Uganda. So what we're trying to do is first of all, understand what copyright and what are some of the laws, sort of doing the stakeholder mapping. And I'm glad that my sister was also talking about something like that, identifying what are the existing laws, the online reforms, and also how does it impact copyright, the digital rights and open access knowledge largely, but also looking at seeing then if we have that, how do we engage the MPs, the people who make the laws like Gilbert, the Uganda Bureau of Statistics, and also the Uganda Communications Commission, that is a huge regulator in Uganda, but also seeing how do we then see how to align the Global Digital Compact principles with the Uganda development goals. So we know that the Global Digital Compact does not really explicitly align, especially with the copyright reforms, but we want to see how do we provide a foundation of discussion around open access, fair digital economy that also Gilbert talked about, but also looking at the AI-generated copyrights concern that is also very important for our community in Uganda and also the Wikimedia community at large. And already having to learn from some of the advocacy groups, especially the Wikimedia advocacy or policy group at the Wikimedia Foundation, that has really provided a system whereby we've learned a lot about copyright, and also we can see how to use the Global Digital Compact framework to influence the future copyright policies, but also promote knowledge equity, that is very key, and digital inclusion. So there's a lot of work that we have to do. First of all, with also doing a number of digital literacy awareness around what copyright is really, what does it entail, how does it impact the users, the consumers, and not forgetting the civil society, but also seeing how to work with the media to raise a lot of awareness in just people knowing that there's a copyright act or a bill in place, and how can the community, the users, use it for the benefit of their aspects. So that is largely what I wanted to say, but also see how to tie it with the open data policy that we have in Uganda, and collaborate with some of the institutions that I talked about, the Uganda Bureau of Statistics, to promote open data policy that enable public access, especially to non-sensitive government information, but also doing a lot of consultation that could advocate for data transparency, inclusion, and also see how we can leverage the existing Wikimedia projects. I think there's Wikimedia Deutschland that's already doing work around copyright to create public, maybe database archives, freely accessible information that we can have this awareness known to the overall community at large. So that is really what I wanted to talk about, and I hope that I've not used your time.
I will penalize you for that later, but thank you so much for that information. So we've heard from government officials, we've heard from civil society, now we need to hear from academia, and I'll invite Professor Sean Flynn, the principal investigator of PIGIPS, which is the Protection on the Right to Research and International Copyright at the American Washington University, AWU.
Take it.
In
Thank
the
you.
US.
So this is super. Thank you for everybody on the panel. And what is my strict time limit?
You have...
As much as I want, eh?
No. I'm running a tight ship. You have 7 minutes.
I get 7. Okay. So, but if I take 5, you'll be happy. So let me... maybe just tie a couple themes together that I'm hearing kind of from the morning into this. And in some respects, I want to take Ian's great quote that I think he attributed to Johan van der Walt of saying, all this practice is very nice, but how does it pertain to theory? And actually, I see a lot of this practice that we've been discussing today very much tying to theory. So what are some of these theories? Intellectual property, historically in the English tradition, comes out of this concept of franchise law. A franchise is a state-given monopoly. And this word actually comes out of the 14th century. And in the English common law, if you received a franchise, back then by the lord of a province, to maybe be the only baker in the town or the only mill owner, then the common law gave you, along with that privilege, it was called, royally granted privilege. That privilege came with a duty. You couldn't have a privilege without a duty. These things were conceptually linked. And so if you received a privilege to be the only supplier of a good or a service in this area, you had a duty of reasonable use. You had to use that franchise reasonably. And what did that mean? That meant that you had to serve everyone on reasonable and equitable terms. You couldn't charge one person more just because you didn't like them. You couldn't refuse to serve this part of the community because you don't like that part of the community. It's actually this book by Haar and Kessler, these Harvard law professors from the 1970s, that said, we find in this concept actually the old birth of civil rights law, requiring that banks serve the whole community. They can't decide to only serve this community or that community. If you have an apartment building, you can't serve only these people or those people. The duty of reasonable service you can think of as being an equality norm. But so intellectual property is a type of franchise. The government gives you a right to exclude competition from others. If I'm a copyright holder, I can say, no, you can't show my movie, you can't sell my book. But that should come with a duty of reasonable use. You should have to sell that product on reasonable terms. You should have to pay the author reasonable remuneration. These are inherent in the concept. We're giving you something, so you have to give back. And so the themes that I'm hearing from these examples, from the South Africa bill, from the bills we're talking about today, from the examples this morning, I think are practical expositions of this idea that you don't have to read the history to do, right? It's implicit. That we see that sometimes when we give copyright, especially if the ones that end up owning that copyright from Ben's lecture are multinational monopolies that don't exist in this country. There are 3 major record labels in the world. There are 4 major publishers in the world. They're not here. And when you give a global monopoly a right to exclude, when you give that franchise to a global monopoly, they don't have a profit-maximizing incentive to serve everyone on equitable terms. This statistic we saw this morning is very interesting. We updated this research that we did many, many years ago. What's the price of Nelson Mandela's book in South Africa? Remember that from this morning? It's 3 times as expensive here as it is in the US. Why? Because there's not very many rich people here. And you make more money by selling a small number of people at a higher price than to serve everybody at a price they can afford. We learned this in the medicines example. It was profit maximizing to serve everybody in the world the same AIDS drugs at the same price, $12,000 a year, no matter what country you lived in. So in South Africa, when South Africa had 40 to 50% of the working age population HIV positive, GDP per capita $2,500 a year, price for AIDS medication $12,000 a year. how many people's entire income has to go to give one person drugs? There's not enough. There weren't enough working people to supply everybody who needed drugs in this country in the 1990s. And so this country said, no, we're not going to do that. We're not going to follow this global monopoly system. We're going to have a reasonable use right. And now in this copyright, we see that too. So reasonable use means fair remuneration. Reasonable use means rights for some of the creators who have been excluded in the system. And reasonable use means fair pricing of the products. It's a very interesting provision. So 2 interesting provisions, and I'll stop, but one interesting provision in the CAB that we haven't mentioned is there's a duty to reasonably price textbooks. And if you don't do it, you get an expanded fair use right. You get to copy the whole book, but only if you fail the reasonable use duty. If you don't reasonably serve the market, then you basically lose your copyright. But that's an ancient idea. Or in Nigeria, we heard today, and I'm going to go read this provision, a public use license. So you can apply and say, this is not a reasonable use. I want to use in the public interest. Maybe it's a textbook, something like this. So I think this is to me, this is what I hear, the connection of the kind of practices that people are talking about to what I do think is a theoretical grounding in this space. So thank you.
Thank you. Thank you so much, Professor Sean Flynn. And now it's the time for me to turn over to the audience for Q&A. I don't want to be mean with time, as I have been with the rest of the people, but in Kenya, we say you should ask a question, do not make a comment if it's a long comment, right? In Kenya, they say mine is a comment, not a question. I want more questions, and if you have a comment, please limit it because we're trying to catch up with the program. And we're doing well. We are only 7 minutes over time, and we started more than half an hour behind. So, burning questions?
It's amazing. You all came and have this interaction with civil society and academia and lawyers as government folks. It's better than WIPO, guys, because we actually trying to create an understanding together in a way. I mean, let me not get too carried away, but you referred to, wouldn't it be nice if there was an active civil society in different places? I think you mean we're the really active ones. We'll go on being active. I've got a couple of questions that follow on directly from Sean's intervention about this duty. When it comes to Kenya, with your new exceptions you're trying to bring in, research and other purposes, text and data analysis, all of that, why non-commercial? Because if you say non-commercial, I mean, you don't have to answer it here, but it's just I'm throwing these ideas out. Why can the other guys, in the States or wherever, do it commercially, but here we'll have to do it non-commercially, if you get me? Vukosi, wants to help people get startups going and do text and data analysis and stuff commercially to make a living as well. So just a questioning, would you open up, would you think about opening that up in the future, that conversation about why only non-commercially as, African exceptions. The Nigerian public, I love that, public interest, partly just because you use that phrase, licensing opportunity, and you still have to define the public interest. And then if you do it, you're still going to be subject to judicial review. So it's going to be a nightmare if you ever do it, not to mention everything that Czeslaw said about whether the politics will be stable for long enough anyway. But let's imagine you do it. Could it be like a sort of big precedent-setting thing? So it might not be just an individual thing, like we are a research body in a small thing in one university Could it be like a big thing where a sort of class of people across the whole of Nigerian society said, we want to, do a huge thing on climate change, or we want to do an enormous thing on Netflix's domination of entertainment in the whole country? Could it address a whole big structural problem? Could you define the public interest so that, someone could bring you an enormous request to sort of, carve something out from copyright? Or is that too big an idea?
Good afternoon, everyone. My name is Kiabetso Yolanda Mkhatusi. I started off indeed as a writer and actress, and very quickly I saw that if I can't control distribution of my work, then I can't control how it will be rewarded. And that's when I added producer to my list of hats. And so now I'm kind of building a company that kind of finds a way to, around the whole distribution or the intermediary problem, and the bottleneck that exists there, but without also trying to be a distributor myself, because it's a whole different industry, skill set, and it's just, you know what I mean? I do what I do, and that's a whole other different job skill. So my question is around enforcement. And Agaba, your little... on our little sheets, handouts that we have there, it says, enforcement needs to your name, and also just the things that you were describing. And Vivian, I think you also spoke about finding in the enforcement agents or mechanisms within what you're doing, and also having an agency that kind of deals with that. And then Professor Caroline, I'm wondering if there's anything like that exists within South Africa. So what have those enforcement agencies been effective at all? And in South Africa, do we have something that is an in-between like that, or is it really just straight to the courts, like that's our only recourse? Thank you.
I've noticed in Latin America a lot, and I've been hearing that here too. All these legal proposals, the bills, the legislative change, how much do they really protect the public interest or the interests of the artists, the local ones, and how much they actually only representing, in fact, hiding the interests of the big transnational companies, as it's been the case in many times. I've caught people like ourselves and other places, politically and legally, having a discourse, or we are protecting the artists, and so on and on and on. They're replicating the arguments of the CMOs, and in fact, they're replicating the arguments of the really big right holders that are not situated in the global south. So are we actually promoting a legislator that's helping them even more, or are we actually changing the course?
And that's for the whole panel. So anybody who feels like touching that can touch that. Thank you. So I will go to the first question, which was from Ben and was directed to Kenya. So Sharon, and he asked about why non-commercial L&Es in the amendment.
Yeah, well, the good thing is that he also said we don't have to answer that today. But just the comment that I'll make is that he said you can think about it. The provision as is now, when it talks about non-commercial, it talks about the exception for libraries and archives, and it has a rider to it. It says where the reproduction is in the public interest and no revenue is derived. Mm-hmm. So that's the provision as is now. I was trying to be very fast, so I wasn't able to go into detail, but I would like to continue thinking about that conversation and picking it up another time. Yeah.
But I think you've answered it. You've given the policy consideration behind that. You've said it has to be public interest.
Yeah.
Lovely. Next, Ben's question was to Nigeria about the public interest definition in the new clause that you were defining, and if it would apply to class actions. Or class action, groups, basically.
I
yes.
Thank you very much, Ben. The section on public interest is novel in the Copyright Act, and it will apply to class, not just individual class actions, groups who are interested in fostering copyright in the public, in the service of the public interest. And the Copyright Act itself does not define what is public interest. Licenses can be granted for public interest, but the Act does not define it. Neither does it define what it is meant actually to rectify a dominant marketplace position, actually. But it does not define what is dominant marketplace. It does not define what is public interest. But the section also gives the Copyright Commission the right to make regulations which will activate the section. And like I told Ben, we had a discussion on this, that the regulation is in the works. Any moment from now, it will be published. We are working on it tirelessly to ensure that that section kicks off. But like I said from the beginning, it is not meant for the enjoyment of an individual to serve a particular purpose. And whatever decision is taken is subject to judicial review. But unlike what Sellers said, it is not politically minded at all. It is the judges are given the opportunity, to look at these cases and also give their judgment on it. And what we are doing now in, creating awareness for the judges, some of them, or let me say a good number of them, do not really understand IP or copyright-related matters, especially for these novel ones that are coming up. So what we have developed, or we are working on, and that one should be out in no short time, in a very short time. We're developing a copyright handbook for judges, and we, regularly have trainings for judges so they get to understand these things and know how to direct their judgments when these matters come before them. Thank you.
Thank you so much.
You're welcome.
Sellers.
Yes, please.
30 seconds.
Yes, just to explain further what you meant by perhaps something big happening that wants to be documented in climate change and all. Some of the images you've seen on global journals actually come from Wikimedia Commons, a media repository of images, videos, and whatnot. So for this year, last year too, Wiki Loves Monument, which is a campaign during which we document various monuments across the world. Nigeria didn't participate for obvious reasons. These regulations she mentioned that are yet to be in place are preventing our images from being left on Wikimedia Commons when we upload them under a CC license. The admins don't want trouble. The Wikimedia legal team cannot engage in trying to, resolve a dispute in Nigeria because a participant in that photo competition uploaded something that there is no actual regulation to give a directive on whether this should indeed go into the public space under CC license. And they say we're not participating until there are regulations that actually defines broadly public interest. Thank you.
I will not allow Sellers to divert us. I can see where you're taking us. We're not going there. You can have a discussion with him over break on that issue. Moving on very quickly, there was a question around enforcement, and this was for Agaba, it was for Vivian, and it was for Prof. Ncube. What is the effectiveness of enforcement in the regions that you are currently representing, is what I caught as the gist of that question. The mic is here.
Yeah, thank you. Enforcement principle is a responsibility of the owner of the work. But in Africa, at least in the case of Uganda, government took the position that we should do something about carrying out this enforcement. It is still a very costly venture to do, but also there are social connotations linked with strict enforcement, which makes doing this work a little bit tenuous as we engage with the process. So our biggest challenge is basically how do you balance the norms of how people access and enjoy these kinds of works vis-a-vis the rights of the owners, and also your responsibility to ensure that there is a rule of law. And that is an unending debate. It goes back and forth. Today, the enforcement must be strict. The following day, you have to stop and let people do what they have to do, these kinds of things. But from our view as an office, one of the things we are trying to do is that we, first of all, deal with the issue of education awareness to ensure that both the owners of the works and also the users know their responsibilities towards this work and educate them. Number 2 is to ensure that collective management organizations whose job is to collect and distribute are actually doing their work. Because sometimes the users say, but I want to pay, but where does this money go? I don't see it reaching the people you say you are collecting it for. So why should you insist on these kinds of things? So ensuring that the CMOs are functioning well. But also on the third issue is something that is still really hard to manage, is that different works have different ways they look at enforcement. For people, for example, in the film industry, their problem is that their content is being outcompeted by foreign works. So they want you to regulate the market, and it's not easy to deal with. The people in music, their complaint is that the platforms that distribute their content are outside our jurisdiction. Why can't you do something about infrastructure to distribute this content and control how our content is shared out online? That's their issue. Then we go to people in the books industry. They're saying, but universities, there's no way we're going to shut down universities. It's impossible. We want people to buy our books. We want them to access our books, but we also want them to pay. Can you put a private copy levy? So forget about enforcement and deal with the private copy levy for them. At least that is one of their ways of dealing with these issues. So it's not easy to find something that is clear cut, but we are trying to engage on all fronts to see how we can help out to ensure there is a rule of law, because that is the reason why we do enforcement. It's a matter of the rule of law, but also the laws are not there just in the books. They must be obeyed by everyone. But it's not easy. It makes our office, actually that's the real reason we have so many politicians intervening, because they think they know better how we can solve this particular problem. But also on behalf of the authors of the work, they feel we are not doing anything for them, which is a challenge. But we'll keep pushing. I hope sometime we'll figure out a balance.
Thank you so much. Thank you so much, Gilbert. I'll ask Prof. Ncube to take the next, and then we'll wrap up with you, Vivian.
Okay. All right. Thank you. I think you've received quite a comprehensive answer, but I think somewhere in your question you wanted to know if there were perhaps alternate dispute resolution methods available to authors. Did I hear you right?
No, here in South Africa.
Yes.
Yeah, so it's no specifically here.
To my knowledge, not really that I used by people, no. But I had a different chain of thought. I thought that people traditionally just use the conventional methods, like they rely on civil remedies. Where appropriate, they might want to lay a criminal charge. But I also feel that typically authors, creatives don't know enough about their rights, and they're not in a position to actually enforce them. And I think there's a gap there. Maybe a gap. We've been talking a lot about a gap, that we say judges perhaps don't know the full extent. We've just heard from government representatives, and we had a question earlier on about judges. And so I think also there's a gap. Perhaps we need to be educating creatives, authors about their rights, and perhaps even also giving them the resources. Because yes, you can litigate, right? But sometimes you don't have the resources. So maybe there's also that gap that we should be trying to fill.
I suppose from our perspective, is trying to be a bit more pragmatic when you look at the enforcement aspect. Who is it that you would want to use as enforcement officers? So in our proposal is to look at the staff of BIPA ourselves, because we also do Companies Act and close cooperation, and there you have inspectors who are supposed to inspect premises and so on. And then we look at law enforcement generally. You have the police, you have people from customs who deal with these counterfeit goods and so on. So the idea is to really empower them to have inspection rights and so on, and also to look at themselves where the extent of exposure that they have also has certain restrictions, so that you don't expose them too much. So it's, I think it's trial and error. You hear the warnings that are coming from other jurisdictions, but the challenge is just that it becomes an issue of he said, she said, and the artists would say we don't have the means to really try and enforce our rights. We've seen it especially in our country where we are not a big population, but we have a vast area to cover if you look at the size of the country. So it's important that you have that support at least from government somewhere, and we saw even during COVID, it was terrible for our artists. They had no income, because the only income they used to use is these jukeboxes where your music is played and then they collect levies. So there's more that has to be done. And I think it's at least some start to see how we can leverage on what is already there. Thanks.
So because of time, I'm going to close the session. I know I've remembered your question, Alan. Anybody who has a burning answer to Alan's question, which was very pointed. Are the reforms protecting local creators, or are they protecting people outside your jurisdiction? And I can see nobody is burning to answer that. So as I'm closing this session, I think we can score ourselves. We can score this session based on how the session started. Professor Ncube started the session wonderfully by giving us about, I counted 7, you can tell me if there are more, issues that could be convergent around the different regions. And I think that what we can tie together from the session are these. Number 1, there is a conversion of issues. That came from the panel itself. Number 2, there is a question around emerging uses. We've heard a lot about artificial intelligence in this panel, and reforms might need to look at artificial intelligence and how they can address that. There is the wonderful issue of the public interest and the definition of the public interest and how these reforms will tackle that. And we have jurisdictions like Nigeria already forging the way ahead. And there has been a ratification and adoption of a number of treaties that looks at the intergovernmental cooperation. And 2 things that I think for me were the best takeaway is public participation and stakeholder widening and awareness. That has been a thing that has been mentioned in all the regions. And I think if you're reforming and you're carrying out these things, then you are on a great track. And finally, capacity building on all tiers of the stakeholder mapping level. And for that, I think we can say this was a very successful session. We need to thank government and CSOs for working together and not fighting. They're very happy, we're smiling, and for academia as well for their inputs, and for you for being on time. And I close this session at exactly 9 minutes past 4 o'clock.